Hi, everybody. It's Dave Stouts from Husch Blackwell. I am the co-practice leader for the privacy and cybersecurity practice with Husch. Would like to thank you for joining the program today. We are going to talk about the nation's almost newest state privacy law out of Connecticut. We're calling this the Connecticut Data Privacy Act. If you want to be technical about it, the bill is called an act concerning personal data privacy and online monitoring, which does not create a very easy acronym. So we have sort of figured out one on our own in the absence of Senator Maroney deciding what he wanted to call this. Although we asked him and he said nothing, actually. I don't think he cares very much what we call it. Anyway, that's me, at least the pre-COVID version of me. I have a beard now, like a lot of us do, I suppose. Just to give you some background, if you use the QR code there, it'll take you to my LinkedIn profile. That's a good way to sort of follow along if you're interested in this area of law. Push out a lot of content on LinkedIn and also on the blog, so just an easy way to kind of follow along here. It's just me here today, sorry to say, but if you have questions, feel free to ask them. You can put them in the comment box. I have not mastered the ability to speak and read questions at the same time, so chances are I will not be able to respond to your questions during real time unless we have some time at the end, but I can look through them afterwards and then respond if I think we haven't addressed anything. The deck is accessible through the webinar slides there. I think there's a resource list button. I don't see the same thing that you guys see, but my understanding is you can download the deck and get access to it. Great. Okay. If you've attended one of our webinars in the past, I like to start with a roadmap. This way you guys know where I'm going with things. A lot of topics here today. 14 is a number of topics, but we'll get through them. We'll go quickly. I think you guys know if you've attended a prior one, we're gonna get through these and give you an overview of this law. To give you the status of where things stand right now with what we're calling the CTDPA. It was this morning transmitted to the governor, so it's passed both chambers. The legislature was supposed to close yesterday. It's transmitted to the governor. The governor has 15 days to act on it. If he signs it, it becomes law. If he does nothing, it becomes law. He would have to veto it. But the margins here in which it passed were, unanimous in the Senate, and I think it was 144-5 in the House. So draw your own conclusions. Expecting that it's just a matter of time for this to happen. A little background then, we're going to sort of pivot into general takeaways, and I'll go to this while I start just kind of talking a little bit about the background here. This bill has been a number of years in the making, right? I think the number is 3 to 4 years, depending upon who you ask. The last 2 years have been led by Senator James Maroney. And I think what's important to understand about this, because this bill, for some people, it may just come out of nowhere. Oh man, Connecticut just passed something. But the reality is, there's a lot of work that went into this. So last year, this time, the legislature closed in Connecticut without passing a bill. They went to, I believe, a special session for budget and tried to get the bill passed that way. And so, that didn't work out, right? So over the summer and after the legislature passed, Senator Maroney had this idea of, if this thing had passed, we would have a work group to talk about certain issues. Why don't we establish a work group anyway? And he did. He established a work group, pulled together a number of people in the privacy space from all different, perspectives and lobbying interests. Some outside lawyers, including myself, and a number of other outside lawyers as well, were able to participate in it and got to working on the bill. And the product of that was a bill that was based off of last year's one, but updated in many respects to be similar to the Colorado Privacy Act. So that's takeaway number one. So if you're familiar with the Colorado Privacy Act, I think you will see a lot of similarity here with this bill, an intentional similarity with this bill, as that was used certainly as a model. But there's differences. There's absolutely differences and important differences. One of those important differences is the strong opt-out regime. I think it's arguable that this has the strongest opt-out regime of any of the bills that have passed. We'll get into that in a little bit later, but that's around the ideas of the opt-out signal, the requirement to recognize that one, and also that opt-outs do not need to be authenticated. Children's data rights is also a place in which this bill goes further than Virginia and Colorado in their bills, their laws, I should say, and has requirements around children's data that are similar to the CPRA. We'll go through that as well. A definition of biometric data. I have a few slides on that, but that's another way in which this bill differs and is more consumer friendly, I think. The right to revoke consent. First of these bills that has the right to revoke consent, which I think is a sneaky important one. And the right to cure sunset. So, this will be 3 states once January 1st, 2025 rolls around. We'll have the 3 Cs, Colorado, Connecticut, and California, that will not have a right to cure violations. And so that really does create this ability for multi-state investigations, right, with these 3 Cs of state privacy law. Virginia and Utah will still have the right to cure violations. And I think it's a big deal, right? I mean, if you can go into a state and cure a violation, then they can engage in multi-state enforcement actions. And that creates, interesting dynamics about, these laws and which ones, are really leading the charge here. The final one on here is no attorney general rulemaking. Wanted to say that up front because I know the question is going to come in. Right now, we're obviously going through rulemaking in California and Colorado. There will not be rulemaking in Connecticut. Bluntly, that was the Attorney General's office's choice. During the work group, it was discussed about having AG rulemaking, and the Attorney General's office decided that they didn't need it. And so we will not be having Connecticut rulemaking, but what you'll see is some of the language in the bill is been mirrored or drawn inspiration from or copied and pasted in some sense maybe from other, Colorado and California to line up concepts, right? And that's a big thing. It was a big part of Senator Maroney's push here to have interoperability with other state laws. If the bill is going to go further in certain respects, fine, it's going to go further, but it's going to be intentionally going further, not to just create issues of interoperability because it wasn't thought about or something along those lines. Okay, enough of this slide. Let's talk about scope. Really always like to lead with scope and then exemptions, and then I lose half of the people, right? They decide they're not subject to the law, and so we lose half of our attendees. Now, but this is, listen, this slide is going to be familiar to you if you've been on previous webinars, right? This is the Washington Privacy Act / Virginia / Colorado model of applicability. You have to do business in the state or you're targeting residents of the state, and then you've got that plus one of these thresholds, right? This 100,000 consumer number, right? Or you're a data broker, right? So what I'll say is on that 100,000 on the top there, that was not always 100,000 each version of the draft, okay? It started at 65 after the work group worked on it. It moved up to 75, and then in the final version that passed, it became 100,000. As a concession to small businesses, it moved up to 100,000. The concept of putting it at 65,000 to begin with was to match the threshold to Colorado. So Colorado is 100,000. One of the next slides, I'll show that to you. And the idea that Senator Maroney had was, well, Connecticut doesn't have as many residents as Colorado, right? So if I say 100,000 in Connecticut, that's going to be a different percentage of the population than it is 100,000 in Colorado. That's why he started on 65,000. He got up to 100,000 though to be, as part of the lawmaking effort, right? To a concession to small businesses. Another concession is that language there that says solely for the purpose of completing a payment transaction. You will not find that language in Colorado or Virginia. The concept there is, they're not trying to get the mom and pop corner shop subject to this law, right? So they're excluding consumers strictly for the purposes of completing a transaction as counting towards this 100,000. Now that's still personal data, right? But it doesn't count towards the consumers. Okay. And there's no monetary threshold. I think that's important to point out as well. In CCPA and CPRA, you've got this 25 million annual gross revenue threshold. It's not here. Consumer, you're going to recognize this definition. Nothing out of the ordinary here. It's a Connecticut resident, surprise, surprise, and it does not include, and we've got the 3 bullet points there. Again, this is, it's not going to include commercial. This is a consumer-oriented B2C bill like we see in Colorado and Virginia. not the employment context. So that's our carved out. Now, listen, we've got to deal with these concepts in California unless a bill passes extending those exemptions. It's not the case in Connecticut, Colorado, or Virginia right now. Talked about 2 slides ago, putting up the scope comparisons here. I thought this would be useful for everybody to kind of walk away with, right? Because I know every time we add another one of these states, the question is, well, Dave, am I subject to these laws? And so this is sort of that, right? You see this monetary threshold in the CCPA and CPRA, that's California, there. So it's, there it's 25 million or 50,000 consumers or data brokers, which is the next slide. CPRA is 25 million or, and it moves up to 100,000 consumers or households. Virginia, Colorado, and Connecticut don't have that 25 million. And then Utah, being the most business-friendly statute to pass, has the 25 million plus 100,000, right? So California it's or, Utah creates it as an additional requirement. For the first time in any of my webinars, I've put the population numbers there. I just pulled those from Wikipedia, right? But what I kind of wanted to draw out there is to show how the threshold of number of consumers is a heck of a lot different depending on the state population, right? 39.2 in California, you're going to hit that a lot easier than you're going to hit it in Connecticut. And then Colorado at 5.8, Virginia at 8.6, right? So that was the concept behind this sort of, when Senator Maroney was looking at dropping that down to 65,000, that was the concept. It became 100,000, but I think as you can just look at the numbers, you see it. I did see a question coming quickly. When you're looking at consumers, it is state residents. If I didn't say that in the last slide, I apologize for that. The other way you become subject to these laws is what I call like the data broker one, right? And so in Connecticut, it's the bottom one there. If you derive more than 25% of your gross revenue from the sale of personal data, plus you control or process the personal data of 25,000 consumers, right? So this is an additional way in which you could become subject to the law. Each of these statutes that we have already has this concept in it, but the pieces move, right? So you see in California and Virginia and Utah, it's 50,000 gross revenue. Colorado, it's just deriving any revenue or discount, right, plus 25,000. So this is one where there's not a ton of focus on it, but if you're basically in the business of selling data, this could be significant to you, right? Or an aspect of your business it does this. This could be significant to you. You might find yourself subject to these laws. And Connecticut is on the grand scheme of things, Connecticut is much more consumer friendly with a lower threshold, 25,000. Colorado is the most consumer friendly here. Okay. Controllers versus processors. This is the terminology that we use in this, again, Washington Privacy Act, Virginia, Colorado, and now Connecticut module, right? Different than California. California uses business, service provider, third party, contractor, right? So those are the terminologies being used in California. This is different, right? But it's familiar to those who've gone through GDPR. There's nothing new here, but this is the terminology we're going to use. This language tracks, everything you're familiar with Colorado, Virginia, et cetera. No surprises here. One thing I wanted to tease out, and I am fully aware that there is a lot of words on paper on this slide. I'm not expecting you to look at this one, but this is how do you tell, right, the difference between a controller and a processor, right? And if you are familiar with GDPR, you know that there's guidelines that have been issued by the European Data Protection Board that go through a number of scenarios. It's a ton of pages there about, well, you might be a controller, well, you might be a processor, right? In this country, in this Washington Privacy Act variant that we have, model that we have, a privacy law, this is basically what we have, right? Virginia is actually shorter than this, right? And then Colorado's got a longer section, and then Connecticut matched Colorado, intentionally matched Colorado. The concept here that I wanted to tease out, though, is at the end of the process of getting the bill across the finish line, there was, again, a concern about on small businesses. And in particular, if you're a controller and you're contracting with a processor, that has a much higher bargaining power, right? You're a mom and pop, you're a small business, you're a restaurant, and you're contracting with, a large company that's your processor to like run your website or, book tables at your restaurant. The concern was, well, there's a disparity in bargaining power, and what would happen if my processor starts doing stuff that with my data? Should I be liable if they do that stuff, right? I mean, I've entered into the contract, but I never intended for them to do this. So some language was added here. The last clause here, which says, and may be subject to an enforcement action under Section 11 of this Act, was added to address that issue. And then the second part as well, and it's in a different section of the statute, of the bill, I should say, is Section 10. And it says, the language here that the C's on is, it says basically if you are the controller, you can't be held liable for the transgressions of the processor unless you had actual knowledge, right? Actual knowledge when the processor or third party was violating these sections, right? So this changed in the last version of the bill that got across the finish line and was voted on. The prior standard was reason to believe. It wasn't actual knowledge, it was reason to believe. Now, having said all that, the language that you see here actually matches Colorado and it matches Virginia. So we've got consistency along there. And frankly, I think it matches European guidance here. There's going to be a lot that controllers are going to have to do in lining up processors. But at the end of the day, if a processor goes rogue, the controller is going to have ways of protecting themselves. Okay. Exemptions, this is just the way in which privacy law, at the state level at least, is developing in this country. We are just exemption heavy, right? And we have our scopes, and we start excluding types of organizations from the scope. These exemptions that are in Connecticut are very much consistent with Virginia, right? And there is ways in which Colorado is more consumer friendly. It does not exempt all of these. The big one is nonprofits. So in Colorado, nonprofits are not exempt. In Connecticut, they are. And then in HIPAA covered entities as well, and business associates, there is an entity level exemption in Connecticut. Again, that was an addition, a change that was made in the last version of the bill. So if you're looking at prior versions of the bill and there was not a covered entity exemption, you're looking at an old version, right? Go find the one that has the covered entity exemption. It's in Section 3A, and you'll know you're looking at the most recent version, the one that actually passed. Higher education as well, universities and the like are exempt. That's not always the case in Colorado. There's a distinction there. Some are and some are not. If you want to look at these exemptions, they are in Section 3A of the bill. Essentially, Section 3A gives like your entity level exemptions, and then 3B, which goes on for a page and a half, gives your data level exemptions, right? With one caveat, which is the GLBA exemption in 3A has both the entity and the data level exemption there. Okay, so in any respect, a lot of entities are exempt from this bill, very similar to Virginia. And then, the list goes on, right? And I don't have every single one here. I think I said it's 2.5 pages long, but just picked up the ones that, people tend to ask me about on a fairly regular basis. And here they are, right? So you can read them as well as I could read them to you, but that would be boring, so I will move on. Personal data. Really no surprises here, right? Again, this vein of Washington Privacy Act, Virginia, Colorado model is much different than the California approach. California lists out every potential data element they could think of, including olfactory information, keystrokes, and that's just not the way that it's gone about in Connecticut or the other model. It just follows the European model. The big thing here, I think, is where the rubber meets the road, so to speak, is this publicly available exclusion and de-identified data exclusion. So those would not be covered, right? If it is publicly available information or de-identified data. So, having said that, publicly available. This is, I think, the larger construct here that people should be aware of is In the CCPA, the California Consumer Privacy Act, the definition of publicly available was much narrower, really just government records, right? And in the CPRA, the new version of California, that's been expanded to this concept of like what you make available to the public, right? So think about like what you put on LinkedIn, right, as being information that you make publicly available. And the concept is, well, if you make that publicly available, that should be publicly available information. Not really there in the California Consumer Privacy Act, more so there in the California Privacy Rights Act, and here in Connecticut, it's there as well. Colorado, Virginia, right? So this is one of these evolving concepts that we have in state privacy law about this idea of publicly available. One thing to keep in mind as you're looking at these bills and you're comparing them is that, it says at the last bullet point there, information a controller has a reason to believe a consumer has lawfully made available to the public, right? So it's the controller's determination here of what's the reasonable basis to believe, right? The other thing to keep in mind as you're looking and trying to match these statutes up is some state statutes say, quote, unless the consumer has restricted it to a specific audience, right? So the concept there is, I've published something on LinkedIn, but I've restricted the audience to certain groups of people, right? That would be the carve out that's not publicly available. It's not in Connecticut, not in Colorado, but that is in Virginia and that is in California. So, keep that in mind that this is relevant to you. The identified data was the other one that's excluded. Really good consistency here between Virginia and Colorado CPRA, right, in Connecticut. So this is really based off of the FTC standard, the Federal Trade Commission standard. And so, not a lot to talk about here. Other than what's on the slide, but really good interoperability here, good alignment between statutes. Okay. Consumer rights. These are consumer rights statutes, so let's talk about some of the consumer rights. It's got all of them, basically. If you attended the Utah webinar that we did, the online webinar that we did, it's a different story, and then in the next slide I'll start teasing that out. But this has the the usual rights that we see in this Washington, and I should say, I keep on saying Washington Privacy Act. Washington obviously hasn't passed the Washington Privacy Act. It's just that was the form that was used in Virginia and Colorado, right? That model was used. So I always refer to it as the Washington Privacy Act model. Some people call it the Virginia Consumer Data Protection Act model. Some people don't care to call it anything. But that's why I use Washington, right? That is that concept of a model as opposed to the California model. Okay. I think what is important to understand on the rights here when you get into the weeds is these rights here, and in particular, if you look at the fourth line down that it says delete personal data concerning consumer, right? There's nuance here. And the nuance to seize on is whether or not these rights extend to all data that a controller has on somebody, or if they only extend to the data that the controller collected directly from the consumer, right? And so, for example, if you look at California's definition, it's the right to delete data that the business collected directly from the consumer, as opposed to everything. And so that becomes significant when you talk about like data brokers, right? And they're collecting data from other sources. Or if you're buying lists, right? You're not a data broker, but you're buying lists. You have to delete that data. So that can become significant. But here in Connecticut, you see, that this extends to all data. So there's more consumer friendly as opposed to business friendly. And there's a ... that I'm going to get to with a data broker exemption in a minute here. Again, trying to draw these together, these different laws. I know we eventually the print, as we add more, the print's just going to get smaller and smaller on these slides. I think we might be at capacity here. But going left to right, we've got California, Virginia, Colorado, Utah, and then Connecticut. We are acronym heavy in the privacy space. Our acronyms are very important to us. So these are at least the ones we've adopted so far. And this is the comparison of rights slide. The next slide will be comparison of opt-outs. When you see the yellow ones, what we're getting after there is, again, this concept of, it provides the right, but it's only what we'd say like is a partial right, right? Because it's not extending it to all data that the business or controller has on the individual. It might just be what they've collected directly, right? Those types of caveats. That's the reason for the yellow. I mean, if you just look at it, Utah is obviously the most business friendly with a bunch of yellow, and does not have the right to correct inaccuracies. Connecticut, like Colorado and Virginia, just checks all of these boxes. The interesting part, I think, when you get into the comparison of rights is when you look at the opt-outs. So Connecticut, again, I've said it before, the opt-out rights are arguably the strongest of any of the laws that have passed so far. You see the boxes are checked green all the way down, and the only other state that has that is Colorado. I think where it differs from Colorado and why I think it's stronger is because of the authentication. There's no requirement in Connecticut to authenticate and opt out, and there is a requirement to authenticate in Colorado. Connecticut borrows from California in that regard, and California doesn't require authentication of an opt out. Is, I make an access request. Please turn over all the personal data that you have on me. Okay. Well, I should probably make sure that you are who you say you are, and that it's actually your data, so I'm not walking myself into a data breach, right? So I want to authenticate that. I want to verify your identity, right? Deletion as well. You can delete extremely sensitive data. Imagine going to cloud storage and deleting someone's pictures of their kids growing up. That would be horrible, right? So we want to verify that and authenticate those things. Those same considerations do not come into play with opt-out rights, right? I want to opt out of the sale of my personal data. Okay, is there a consumer harm to opting somebody out of the sale of the personal data? I'm not disclosing data to anybody. I'm not deleting data. I'm just saying I'm not going to sell your data. So conceptually, when California put this together, they drew that distinction between the two. In Colorado, though, everything is authenticated. Same thing in Virginia, right? Everything's authenticated. But Senator Maroney did not want to have all the opt-outs authenticated in Connecticut, which again is why I think that it's arguably the strongest. It pulls both concepts between California and the other bills together. The other way in which it's strongest, I believe, is that last line, to recognize the opt-out signals, right? So, this is the concept there being, do I have to go to every single website that I visit, and do I have to click on the do not sell my personal information link and opt out of targeted advertising or the sale of personal data, however you want to define it, in every single site I go to? Or can I go and download one browser extension or one browser and use that, and I will opt myself out of everything? One choice that the consumer makes versus hundreds of choices the consumer has to make on every website. And so Colorado said you've got to recognize the opt-out signal. Connecticut also says you have to recognize the opt-out signal. California had that yellow because, yes, today the AG's office has said that businesses need to recognize the global privacy control signal. If you're not doing so, you should send me an email. We should talk about it, right? Today it's required, and they're enforcing that requirement. In the CPRA, it is discretionary. The language becomes discretionary. Now, we'll see what happens in the rulemaking. I think there's a lot to be decided. We wrote an entire blog post on all these things, but that's the concept of why we have it yellow here versus green. And so that's why I think at the end of the day, this is a significant step for Connecticut in this grand scheme of things. Okay, enough about that. Talk about the right to delete exemption. I talked about this or alluded to this a few slides ago. This is basically, to cut to it's a data broker exemption, right? The highlighted language basically is you are a controller, you're collecting data from a source other than a consumer, and you get a deletion request, right? What do you do? Well, one concept would be you delete the consumer's data, right? But the concern is with data brokers is, well, I'm always ingesting data, right? If I'm always ingesting data on consumers, and you come to me on a deletion request, I delete your data today, but then it shows up again tomorrow, right? It puts me in a situation in which it's difficult for me to comply, and I run myself into a compliance hurdle. This really got teased out in the Virginia the Virginia work group. You may recall Virginia had a work group this year, and they eventually added language in Virginia on this exemption that said, okay, if you were in that situation, this is what you need to do, A or B, right? And so this was also added into the Connecticut law to allow for those data brokers or that ingesting of data on a consistent basis to comply in a different way. Colorado doesn't have it, but Connecticut and Virginia do. Okay, opt-out rights. Talked a little about this before. Just give you some definitions here. You got three opt-out rights, right? You've got sale, targeted advertising, and profiling. This is the definition of sale. Worth pointing out here that we've got the broader definition of sale, so it's monetary or other valuable consideration. So Virginia doesn't have the other valuable consideration. Utah does not have the other valuable consideration component. So we've got the broader definition here. Exclusions, these are going to look familiar to you guys, right? If you're familiar with this model, we did a whole Saysville blog post on comparing California, Colorado, and Virginia. If you're really interested in getting into the weeds here, you can put yourself to sleep reading about exclusions, the opt-out of sale, but it's out there if you want it. One thing, that last bullet point there, disclosure as part of a merger, acquisition, et cetera, that's also a proposed merger, acquisition, or et cetera. That's not in every privacy law out there, the proposed aspect of it, but it kind of recognizes if you are a lawyer and you are doing a lot of due diligence in M&A, that you might need to transfer personal data to be able to do that due diligence. So anyway, it's there, and I think it's a good addition to the bill that happened as part of the work group this year. Opt-out of targeted advertising, again, conceptually similar, language is similar to what we know out of this Washington Privacy Act model. So really, should not be something completely new here for you guys. I think when we look at this issue here, I think really where the issue is going to be moving forward in the next few months is how does opt-out of targeted advertising compare against California's right to opt-out of sharing, right? I mean, sharing is disclosures for cross-contextual behavioral advertising. And there's language that's similar between the two models here. There's language that's different. I look at one of these concepts and I think it's going to be one of those things that privacy lawyers are going to be thinking a lot about, especially with the rulemaking that comes out, the comparison between those two, right? And trying to match up those two concepts between the California model and now this Washington, Connecticut, Colorado, Virginia model. So that's what I'll say. Again, targeted advertising, what does it end up being if you're not familiar with this? This is like third-party tracking technologies, cookies, those types of things, right? I'm being tracked across the internet. If you watch these committee hearings, if you watch these floor debates, you will hear this as being the prevailing issue, right? Is, hey, I was talking out loud in my living room about X, Y, and Z, and then 10 minutes later I see an advertisement for X, Y, and Z on my phone, right? This is a lot about what these privacy laws are about, or opting out of targeted advertising. It's a lot of what underpins the issues that these lawmakers are trying to get after. Okay, apologies if you are hearing what sounds like a fire truck in the background, but it seems like it's gone now. Okay. The third one then is the opt-out of profiling. Again, a lot of similarity here to Colorado, Virginia. One thing to point out is the last bullet point here, which says it has to be in furtherance of solely automated decisions. Solely automated language is not in Colorado or Virginia. We'll see how it plays out. I think this as well is going to be a concept that we need to think a lot about. This has been identified. If you're tracking what's happening in Colorado with the rulemaking process there, Attorney General Weiser has identified profiling as one of the subjects that they're really looking at right now, and I think with good reason. The issue of the concept of profiling is defined in the CPRA. It was not defined in the CCPA. So again, one of these new concepts that we didn't really wrestle with so much in CCPA compliance, but for 2023 compliance, we're really going to have to spend some time thinking about whether this is happening. Conceptually, right? It's this concept of do you have the computer deciding and making decisions about you, about whether you fit a certain profile without a human interacting there? Are you, already excluded from, some sort of benefit or financial option or discount or something along those lines because you don't fit the right demographics or you don't live in the right regions, those types of things, right? I mean, that's the concept behind the profiling, but there is, infinite ways in which that could play out, into use cases that I think it's just really going to take time for this to develop. Okay. Sensitive data. If you're familiar again with these models, this Washington Privacy Act model, this is really an important distinction between the Virginia, Connecticut, Colorado way of going about it and the California way of going about it. And frankly, Utah just got itself out in left field on this issue. But for Connecticut, Colorado, Virginia, you need consent for the collection of sensitive data, right? And this is the categories. These 8 categories are sensitive data under Connecticut law. They are also sensitive data under Virginia law. They are, with one exception, for Colorado. Colorado does not have precise geolocation data in its definition. California juxtaposed that. So here, in this model here, Connecticut, et cetera, consent, user consent, right? In the California model, you can collect sensitive data, but you have to keep your processing activities in a certain box, limited to certain actions. If you stray outside that box and you process sensitive data for other types of things, then you have to give consumers the right to limit you back down to it, right? So it's the right to limit the use of sensitive data. Again, we did a full article on this. It's on the blog if you're really interested in, falling asleep at night quickly, dig into it. But conceptually, this is, Connecticut has this consent to process sensitive data. I mentioned Utah as well. Utah is, they had the category of sensitive data, but they got rid of the aspect of consent. I'm not even sure what bluntly, I'm not quite sure what the purpose of the category is. There's a notice aspect to it. It's just, Utah's not going to be the one that you're talking about. The one that you're going to be talking about is this model here. Okay, one part I want to seize on here is number 6. You look at number 6, it says genetic or biometric data for purpose of uniquely identifying an individual. Okay, next slide then, biometric data, right? This is the first sentence of the definition of biometric data. And again, if you are looking at a prior version of the Connecticut bill, you will find this sentence, right? You also find this sentence in Virginia as well. This just tells you, biometric data is, and it makes a lot of sense, right? It's automatic measurements, fingerprints, voice prints, et cetera, right? A second sentence was added in, it may have been the last version of the bill, the last Senate amendment, it might have been the one before that, I can't recall off the top of my head. But a second sentence was added after the first sentence, okay? That sentence is on the left side here under Connecticut. And it says, it does not include, so read the subject heading, biometric data does not include a digital or physical photograph, audio, video recording, any data generated from that, unless it's used to identify a specific individual, okay? Juxtapose that versus Virginia on the one there, right? Virginia just says it doesn't include a digital photograph, video, or data generated therefrom, right? It does not have this highlighted language of unless such data is generated to identify a specific individual, okay? This is intentional. This is completely intentional. It was language proposed by a privacy group. There was a big debate over this one, right? Obviously, the Virginia one is much more business friendly, right? It arguably excludes facial recognition. It arguably excludes, voice recognition and those types of things. Connecticut does not. Connecticut covers it, right? Because that's data that's generated to identify a specific individual. So it's covered. And all of the articles that have come out afterwards have seized on this, appropriately have seized on this, right? So Connecticut's more business friendly and could potentially cover a lot more of your processing activities if this is what you're doing. However, though, this is not new, what Connecticut is doing. This lines up with GDPR Recital 51. It lines up with European Data Protection Board guidelines that were published with respect to video devices, right? So this is conceptually, it's there, and it exists. Now, you'll say, okay, what about Colorado? Well, Colorado doesn't define biometric data, right? It has been thought, and we'll see what happens, but it has been thought that biometric data in Colorado will be defined during the rulemaking process, okay? And so I would think that if you're in the Colorado Attorney General's office and you were thinking about the definition of biometric data, because honestly, it has to be defined. You can't say you need to consent to collect something and then not define that, right? I would think that Colorado AG's office will look really, really hard at what Connecticut has done in its definition and look at potentially adopting that one because it's more consumer friendly than the Virginia model, and frankly, the AG's office is more consumer friendly in Colorado. So an important distinction there, anyway, for some companies. The CPRA definition, I'm not going to do anything with this one. I just thought 2 nights ago when I was putting this deck together, I thought somebody would say a question of, okay, how does California define it? So I just threw the venom and put it up there. So it's there. If you want to download the slide deck and take a look at it, you can dig into it. It has keystrokes in there. Keystroke pattern and rhythms is something that I was talking with a client about yesterday, about that language. Okay, what is consent then, right? The yes column, clear affirmative act, written statement, electronic means, conceptually familiar to us, right? This is concept of GDPR. This language is similar to California and Colorado as well, right? And then the right box is, well, what is not consent, right? Acceptance of broad general terms, right? This is going to be stuff that you have to focus on when you're collecting this data. Can you just throw this into your terms of use and those types of things? The answer is no, right? You got to think about how you're going to collect this. Now you're going to collect the sensitive data in a way in which it actually complies with the yes side, a freely given, specific, informed, unambiguous agreement, which are concepts we are very familiar with GDPR. There is a lot of guidelines out of the European Data Protection Board. And I know it's strange to keep on referring to Europe, but that's because these concepts have come from Europe, right? And so privacy lawyers are going to be looking at European guidance and interpreting them. Say as well, Colorado has the same general definition here. I don't know if it's word for word, but it's the same concepts here, all of it. Colorado is going to be doing rulemaking, and they've identified consent as being one of those concepts here that they're rulemaking on. And so, you see alignment in that regard, and purposefully. And I think California may do some as well. California, understand that California consent is not as big a deal in California under that model as it is in Virginia, Colorado, and Connecticut, obviously. Number 3 here, just to tease that out, dark patterns. It seemed like this concept is getting a lot of traction recently. There was an enforcement action against a large tech company over the idea of dark patterns. They come in a lot of different, I'm not going to use the word patterns. I'd be defining it by use of the word. Defining the term by use of one of the terms. Dark patterns come in a lot of different variants, we'll say it that way. So that would be concepts like, cookie browsers, right, where like the reject all button is much smaller than the accept all button, those types of things. Or one has gotten a lot of traction recently is the idea of like, you sign up to get a subscription and you're like signed up for life and it's impossible to cancel, those types of things, right? I saw one recently where it looked like, on your phone, it looked like there was a hair on the phone. And so you would go to, swipe the hair off of your phone, and that was actually acceptance, right? So that's like next level type dark patterns, but in any respect. So, this again, dark patterns was identified as a topic for rulemaking in Colorado. It's in Connecticut. There's a wrinkle in Connecticut where the definition of dark patterns talks about FTC. Anything the FTC would say is a dark pattern. That was just part of the lobbying back and forth effort, so that language is added there. It doesn't, I don't think it conceptually changes anything in the way that Connecticut addresses it. Okay, one way that does conceptually change things in Connecticut, though, is the revocation of consent. You will not find explicit reference to the right to revoke consent in Colorado or Virginia, or California for that matter. In Connecticut, it specifically says in the bill that you have the right to revoke consent, and that the right to revoke must be as easy to revoke as it was to give consent in the first place, right? This is straight out of GDPR. I mean, it is, right? And one could argue that it is implied in Colorado. One could argue that it is implied in Virginia, but I don't actually know that to be the case, right? I think you'd have to look at case law about consent and other concepts and see whether revocation actually is there. I mean, there's a reason why it talks about revocation and consent in GDPR, right? It's because it's a specific right that wanted to be granted. it's in Connecticut. It's one of the ways in which Connecticut advances the ball a little bit on the privacy issues. Here, I think the issues that we'll start talking about are things like, okay, somebody's revoked their consent. Does that mean I have to delete the data, right? And I think we will be looking at GDPR and instructions there about, I think you're going to be deleting data in those regards, unless you have a lawful basis apart from consent to keep that. And we're going to be looking at Section 10 of the Connecticut bill, which has the limitations section there. Okay, so again, an important distinction. Another important distinction then is children's data. So if we were looking at Colorado and Virginia, I would just have the under 13 section here, right? If I was looking at California, I would also have the 13 to 15 section here. Connecticut matches California in this regards. The first of these bills in the Washington Privacy Act model that advances children's rights, right? It basically says that you need consent of if it's under 13, the parent. If it's 13 to 15, then it can be the individual. But you need consent before you do targeted advertising and sale of personal data, right? This is intended to protect kids online. But the caveat is the controller needs to have actual knowledge and willfully disregard that as a child at those age ranges. So California, the language I think is a little bit more consumer friendly. It's actual knowledge, which can be willful blindness. Connecticut's a little bit higher standard, I think. We'll see how it plays out in the enforcement actions. But as you hear talk about why Connecticut's stronger on children's privacy rights, this is why. This bottom part there, 13 to 15. What I should also say is until the last version of the bill, the number was under 18. It was back down to under 16 as part of the last version of the bill. So if you're looking at 18, you're looking at an outdated version of the bill, throw it away, get yourself the one that says under 16. Okay, control obligations, consumer requests, you're going to know a lot of these things, right? You have to accept consumer requests. Not as prescriptive as California is. It matches Colorado. It matches Virginia in the ways in which you're going to be receiving consumer requests. I think, kind of moving on, we were talking about the opt-out, right? Again, really, want to emphasize this opt-out preference signal, right? As of January 1st, 2025, you have to allow opt-out the preference signal. Now, I don't know if the questions come in. I haven't been able to read them, but one of the questions I'd be thinking about right now would be, okay, well, what about the technical specifications? If there's no rulemaking, then how are we going to know what preference signals need to be recognized and how do we know what not? It's a great question. What I will say is that the language in Connecticut around, what needs to be recognized as an opt-out signal mirrors the language in Colorado. So we will have rulemaking in Colorado about these contours of signals, and the language in Connecticut matches Colorado, so you could associate the two, right? One way in which, problems were tried to be solved absent rulemaking, okay? Consumer requests, I think, this is very familiar, right? So you have 45 days to respond. It's a different time frame than in California, but I think people are just going to align their response procedures along like the shorter time frames. Again, I talked about authentication not required for opt-outs, and that's going to track the CPRA. Appeals. Well, let's talk about that for a second here. This is a new concept that is going to be in place in Virginia and Colorado and Connecticut, not in Utah and not in California. The concept is basically, consumer makes a request, I go back to them and I say, go pound sand, we're not going to comply with your request for whatever reason, right? Virginia, Connecticut, and Colorado are going to require you to have an appeals process for that, right? What does an appeals process look like? That's the question. I want to kind of figure that out, what an appeals process looks like. It's not prescriptive in the statutes, but I think it's going to be, I want to provide you more information. I want to understand why you denied my request. What if I got you X, Y, and Z? Okay, well, you say you can't authenticate me. What about X? What about Y? Those types of things, right? So anyway, I mean, this is an aspect here that we haven't had to wrestle with respect to California heretofore, but it's a new one that we're going to start tinkering with, our consumer request response procedures and have to really adapt in there. Okay. I should say, one thing I forgot to mention, and thankfully I have notes and occasionally refer to them, is this, the opt-out, the authentication issue. It is, I said before, that Connecticut mirrors and it matches California, right? Under the regulations in California, you can still deny an opt-out if you, the business, had a reason to suspect that the opt-out is fraudulent, right? And there's some other language there too, but it's essentially fraudulent, right? That language, in the last version of the bill that came out, that language was taken from the CCPA regulations and put into the Connecticut bill, right, to align it with California. So yes, is authentication required? No, for the reasons we talked about before. However, if I'm the controller and I have a reason to suspect there's something fishy going on here with this opt-out, I've got the ability to deny it. It's a good compromise there between business interests and consumer interests in this regard. I mean, businesses aren't going to be, beholden to fraudulent opt-outs and those types of things. Okay, meant to mention that before. Sorry about that. Privacy policy. Yeah, I mean, surprise. There's a privacy policy provision in this bill, in this privacy bill. And it matches. I mean, you could read up and down here and you'd say this all seems very familiar to me, with the exception of number 6. Number 6 is active email address. Your privacy policy has to identify an active email address or other online mechanism that the consumer may use to contact the controller. I mean, frankly, we have this, typically we have a contact us section. I say typically, always we have a contact us section at the end of at least our documents that we do. But this was a big, funny enough, this was a big issue for Senator Maroney, who said, it was a frustration that, you try to contact somebody and you can't find a contact address for them. So they want it there. They want something to actually be a contact address. Not a big deal, but like subtle ways. I mean, I think what you see, right, is it's interesting, right, because you see this laboratory of democracy issue happening, where at the state level, a lot of smart people get together in one state and they come up with what they think is the best. And then it goes to another state and like other smart people look at it, right? And they come up with like additions and thoughts and those types of things. And so, like, yeah, it's a wrinkle. It's not like, Betty bar the door type stuff, but it is an interesting aspect of how different people looking at things over time can update these requirements. Data protection assessments. Listen, guys, this is a big deal, right, in my mind at least. So if you're engaging in certain processing activities that are considered to be heightened risk, then you are going to have to do data protection assessments, right? So this is, the way the statute's laid out, it says it's heightened risk activities, right? Heightened risk to consumers, and then it gives these examples: target advertising, sales, processing sensitive data, profiling, right? Certain types. It matches Colorado, okay? The way that this is laid out intentionally matches Colorado, and it is conceptually the same as Virginia, right? Colorado is doing rulemaking, and they've talked about doing rulemaking on what this data protection assessments would look like, right? But I think for your purposes, if I was thinking about like, okay, I want to comply with these laws, I'd be thinking that this is something to get started with now, right? And the concept is, you've got to identify these processing activities. You have to identify your sales, identify your target advertising, identify profiling, and then you've got to go through this process of like weighing the benefits and the risks to consumers. And then, whether you can use the identified data, et cetera, et cetera. The good news is it only applies to processing activities after July 1st. But let's be honest, it's not like, you're sitting around and as of July 1st, 2023, you're going to engage in like different processing activities. It's just going to be the calendar changing, right? So one aspect in which you can get started. So I mentioned Colorado's going to have rulemaking on this, but they've already talked about that being not prescriptive, right? Not like X, Y, and Z. They talked about that being principle-based type rulemaking. So I think time can be spent identifying these activities as part of your records of processing activities, and trying to use this to drive compliance. One, good aspect of this, we talked about this in prior webinars, is the attorney-client privilege. So you are, capable of having attorney-client privilege over aspects of these data protection assessments that would, necessitate privilege. And the fact that you have to turn it over to the AG's office does not waive the attorney-client privilege. So something to think about. Another one, data processing agreements. Again, one of these things that if, This is a big change for U.S. law. It's not here yet. It's going to be here with California. It's going to be here with Colorado. It's going to be here with Virginia, and it's going to be here with Connecticut. Utah has it as well, but as you might suspect, far less so. The concept is, and if you haven't gone through it before, is if you transfer personal data to a processor, or you are a processor receiving personal data, then you're going to have a contract, and that contract's going to have to say certain things. If you are doing GDPR compliance, this looks extremely familiar to you, right? But for U.S. companies who haven't gone through that yet, you're going to have these agreements in place. It's just that simple, and that's why we talk about, like, now's the time to start getting your contracts in place, identifying the relationships that will require these. And if you look at the last two, right, opportunity to object to sub-processors, so that's, if I'm a controller and I go to a processor and that processor is using like AWS for storage, right, or something like that, I need to be aware of that, and I need to have an opportunity to object to that sub-processor, right? And also the next one there, push down obligations to sub-processors. So that's, that processor I've gone to needs to push down all of these contractual obligations to sub-processors, right? So point being is, this is work to be done, identifying your processors, identifying, who you use, having a list of those if you're in a processor relationship to be able to provide, so it provides an opportunity for the other party to object. That's work that can be done. It's not something that you show up the day before, the deadline for compliance and we're able to get across the finish line in any respect. Something to think about. Okay, other controller duties, we can kind of like buzz through this, right? Duty of datamization, void secondary use of data, very similar concepts that you find in the Colorado law, obviously. But there's other things like, you can't collect data for one purpose and then decide you're going to do it for a different purpose. If you want to do that, then you've got to get consent from the consumer. Okay. Processor obligations, here you go. This is it. Assist controllers with assessments, with breach responses, with consumer requests. That's basically what it comes down to. Similar to GDPR, these laws are controller heavy. They are focusing on the controller relationship and then expecting controllers to push down these obligations in the B2B capacity as to processors, and that's what we see here. Limitations. So if you get to the end of the bill, you see a laundry list of limitations. These are a few, right? Like this, and what essentially says, this law does not prevent you from fulfilling a warranty. This law does not prevent you from preventing fraud, right? So, these are common sense type things, right? And, there's an argument made that this is kind of like a backwards way of getting around Article 6 in GDPR, which, is another day to describe that. But basically, there's ability to do certain things with data that would make sense to you, protect life or physical safety, right? You don't have to, like the guideline there, bleeding out, you don't have to say, like, sir, can you please give me consent to collect your health information, right? You're allowed to do certain things. In any respect, so there's the limitations. I just gave you a few. There's a laundry list of them, right? And we've got 2 minutes left, and I want to make sure I get the last 2 slides because it really is kind of important. Enforcement. There's no prior right of action. I'm sure I've got 12 questions on that already in the Q&A. It's AG enforcement. There is a right to cure. It goes away December 31st, 2024. As of January 1, 2025, you'll have 3 states, Colorado, Connecticut, and California, the 3 Cs, that do not have the right to cure. That's a big deal, right? We talked about that before, but I want to tease that out again. These violations that we talk about, like, they start to add up when you think about there being multi-state enforcement actions. They start to add up, right? So enforcement is coming, and it's just a matter of time. The effective date, here we go. Well, actually, I think we missed one. I missed one slide, sorry. There's task force. To be determined on some of these things. As part of the bill, there's actually going to be a task force that's convened by September of this year, has to provide a report. Concepts like, algorithmic decision-making, children's data, exemptions, those types of things. So just like we saw in Virginia this year, there might be an opportunity to have other amendments to the bill before it becomes law. This was one of the ways to get across the finish line as well, to the extent that there was an entity that felt like it wasn't being properly accounted for, or a concept was, there's going to be a task force that's going to start in September to try to address these issues. And so I sort of jumped the gun on the effective date. There you go. It matches Colorado. So we'll have California and Virginia to ruin your Christmas, and then we will have Colorado and Connecticut to ruin your early summer, And then I don't think we're going to do much with Utah, but we'll find out. Anyway, so that's what it looks like. It's matched Colorado, and I think that makes sense given how much of this pulls from Colorado. You know, we're at time, so I'm not going to. I talked a lot about these concepts of ways to start compliance, and I think you guys can dig into this with the slide deck. I mean, there's a lot of ways you can start now, even absent rulemaking. There's a lot of ways that you can start now. What I'll end with is always what I call the shameless plug portion of this. You know, we have a blog. If you're not subscribed, please do. Use the QR code there to subscribe. I think this one's actually kind of interesting because you can see on the blog there that we've got our podcast series where we talk with Connecticut Senator James Maroney in September, right? And that's, you know, I think if you're not tracking a blog, you know, I suggest over the podcast. I mean, we're trying to talk to these people before it happens, right, and get some inside information in that regard. And then one more shameless plug here. I talked a lot about the guide we put out, kind of comparing a bunch of provisions. I suppose with Connecticut, now I'm going to have to do a bunch of retinkering on these things or add Connecticut to this, and I guess maybe I'll reluctantly do Utah as well while I'm doing that. But in any respect, if you want to get after those articles I mentioned a few times, you can use the QR code. With that, I have only gone 1 minute over time. I see there are questions. I will do my best to get back to any that have not been answered. And I would like to, again, thank you for joining us for our webinar today. Hopefully you found it useful, and hopefully we'll see you on the blog or on future webinars. Thanks again.